welcome back to the Bridge Summit 2025 with Privado AI. I'm Robert Bateman, a data protection consultant, here to bring you the next session, which is a look at the evolving regulatory landscape in Europe and the US. I've got two esteemed data protection and privacy experts to talk us through both landscapes, both of which are evolving in very complicated and fast-paced ways. So the first of two presentations will be by Matthew Nuding. Hello, Matthew. Would you like to say a quick hello and introduce yourself to the audience, please?
Yes, thank you, Robert. My name's Matthew. I'm an associate in the London office of Wilson Sonsini. We're a full-service US law firm that, based out of Silicon Valley, focused on advising tech and life science companies on areas around privacy and AI and all sorts of regulatory matters more broadly.
Thank you, Matthew. So you're going to talk us through what's happening in the UK and the EU, and you got a presentation, so please take it away. We're just waiting for that to come up on the screen, and I'll see you once you're done.
Great, thanks, Robert. So as Robert mentioned, I'm Matthew, and I'll be going through a bit of an overview of the privacy regulatory landscape in Europe. By Europe, I'm referring to the EU, and also we'll be discussing the UK. There's a significant degree of overlap with these jurisdictions in terms of the issues, the privacy issues that regulators are focusing on, and there's also some differences which I can highlight in the presentation. So onto the first slide here. So what are the key kind of privacy issues that we foresee in 2025 from a privacy perspective? First of all, we'll be looking a little bit at children's privacy. We'll then be discussing AI, and in particular, generative AI. Next, we'll be outlining some of the issues surrounding international data transfers, and then finally focusing on cyber and data security. These are just a few highlights for 2025. Obviously, there's so many more things that we could have mentioned, but we're obviously limited to the time. So this is just what we decided to focus on. This is what we see are kind of the main issues for 2025. So firstly, then looking at children's privacy. Going on to the next slide. Children's privacy has been quite a big issue from a regulatory perspective over the last few years, but we're definitely seeing that 2025 is set to be a significant year from a regulatory perspective. We've seen kind of, a number of laws that are kind of really coming to fruition, and obligations arising on companies that will come into play this year in 2025. So firstly, then focusing on the EU, we will have guidance on the protection of children's data is planned to be released by the European Data Protection Board. We're also going to see, from the perspective of the Digital Services Act, the European Commission will be adopting guidance on the protection of children online by the summer of 2025. So the Digital Services Act, although it's not necessarily a privacy regulation, does have, of course, implications for children's privacy, and has a requirement that online platforms take measures to protect children online. And one of the prohibitions as well is that online providers can't profile minors' personal data to target them with ads. So we're going to see in that guidance issued by the European Commission a focus on identifying and mitigating risk to children on a platform, and also then looking at the very difficult issue around age verification. Of course, that comes from the perspective of online safety and protecting children from particular harms and preventing them from accessing particular websites and services that might not be appropriate to them. Of course, any kind of age verification tools will involve significant privacy issues and implications. So it's very important to consider that, consider privacy from that perspective. Moving over then to The UK, we've seen the UK privacy regulator, the Information Commissioner's Office, has focused on children for a number of years, and it is continuing its focus into 2025. Of course, it has the ICO has a children's code, which sets out 15 standards for companies offering services to children to comply with from a data protection and privacy perspective. As part of that, they have a children's strategy that this year will focus on a number of different issues. So I've listed them on the slide there. So firstly, we'll have focus on default, privacy, and geolocation settings. There'll be a focus on profiling children for targeted advertisements. As well, then another focus will be using children's information in recommender systems. So that's something that ICO will be considering this year. And then also the use of information of children under 13 years of age. So we can expect the ICO to be being quite active on children's privacy throughout this year. And they have already in 2024 contacted and are engaging with a number of different platforms that offer services to children from the perspective of protecting children's data online. Then, of course, as well, the Online Safety Act, the children's code duties will be coming into force this year. Some of those requirements and some services will be required to implement highly effective age assurance, similar to what I mentioned with regards to the EU and the DSA. Of course, any kind of highly effective age assurance is going to have implications from a privacy perspective. So we can consider that's going to be a big focus for this year. Moving on, in the interest of time, we'll discussing then AI. So on to the next slide. Just press it here. AI, of course, no privacy event would be you couldn't not mention artificial intelligence and in particular generative AI. We will see, we'd expect regulators continuing to be quite active in this area. In terms of the UK regulator, the ICO, and also with EU regulators, they've both over the last year been considering their position on how data protection law applies to generative AI systems. As we saw a consultation report issued by the ICO just in the last 2 months, which was the outcome of their consultation on how data protection law applies to generative AI. And we will expect that they are going to update their guidance on AI and data protection law this year after the Data Use and Access Bill is passed. Similarly, with the European Data Protection Board, we've seen that they've released an opinion on generative AI and how companies can comply with data protection requirements and some of the considerations they need to bear in mind. Similarly, I think we're seeing these regulators have kind of finessing and coming to their kind of positions on how data protection law applies to generative AI. So we would expect that they will start to kind of begin to being more and acting more and sending out more requests for information throughout 2025 in this area. That's not to say that regulators have not already been quite active in generative AI. We've seen a number of regulators increasing by the day, issuing requests for information and investigations to DeepSeek just over the last 2 weeks. So that's not to say that regulators, where they see non-compliance or suspect non-compliance with the GDPR, that they will not take swift action, including blocking on certain services as well. So then just quickly moving on again, in the interest of time, discussing then international data transfers will, we suspect, continue to be a significant issue. The EU-US data privacy framework, we would likely expect that there may be some developments amidst possible EU-US trade tensions, particularly with the current administration and some tension there. It's something to definitely consider throughout 2025. We've also could expect more regulatory action in this space after a number of blockbuster fines issued to companies over the last 2 years. So last year, we saw the Dutch Data Protection Authority fine Uber for 290 million euro for transferring personal data of EU drivers to the US. And the year before, we saw the Irish Data Protection Commission fine Meta 1.2 billion euro, also related to transfers of personal data of EU individuals to the US. It's not just transfers to the US that we suspect will be a focus in 2025, but also we would see potentially some discussion around a potential regulatory action around transfers to China as well. So at the start of 2025, the organization NOYB filed a number of complaints against Chinese-owned companies for transfers of personal data to China, where they suspect there was not adequate protection in place. So we would expect that there may be some potential regulatory action in that space. So that's definitely something to consider in 2025. And then finally, just the final issue to discuss is cyber and data security. Of course, the GDPR has requirements around implementing appropriate security measures to protect personal data, and also requirements around notifying breaches to affected individuals and regulators when applicable. We will, I suspect, continue to see action against companies with regards to security requirements, and not just on controllers, but also we're seeing more regulatory action against processors as well. So just because you're a processor does not mean that you're off the hook in terms of your Article 32 GDPR requirements for protecting personal data. An example of that is the UK Information Commissioner's Office. It announced a provisional fine that, of course, is still subject to change and is only provisional, but against a data processor in relation to a data breach that occurred that the ICO suspects, or the ICO expects they did not have adequate security measures in place. That will be a focus, and then also we'll see EU cyber rules are starting to come into force. So laws like the Cyber Resilience Act, NIS 2, and also the Digital Operational Resilience Act, which of course will all have implications in terms of data breaches and security measures that organizations should have in place. So those are the slides that I had there. So thank you very much for the opportunity to speak.
Thanks so much, Matthew. That is looking seriously complicated, and multinationals, of course, have to grapple with European and UK divergence to some extent now too. I'm about to bring on our next speaker, who will be talking about things on the other side of the pond. Here is Keir Lamont from the Future of Privacy Forum. Keir, take it away. Oh, you're on mute, Keir, I think. Unfortunately, I still can't hear Mr. Lamont, which is a great shame, because he has a lot to say about privacy regulation in the US, particularly at the state level. Do you want to try again, Keir? Just say a couple of words. I don't know if anyone from Privado has an insight as to what's happening with Keir's sound. Still nothing, I'm afraid. Perhaps while Keir is sorting out his technical issues, or our technical issues, I could have a quick chat with Matthew about his presentation. Welcome back, Matthew.
Thanks, great to be back.
Unfortunately, Keir appears to be having some technical difficulties, or there are some technical difficulties occurring. So I mentioned just there, Matthew, that organisations working with both UK and EU data subjects might expect some divergence. We're already seeing that to an extent with the ICO's guidance recently on consent or pay, for example, slightly different from the EDPB. The UK obviously has a bill to reform the UK GDPR in Parliament. Do you think we're going to see organisations having kind of carving out compliance programs to differentiate between the two regimes, or do you think they're going to be able to continue to take a kind of one approach for both jurisdictions?
Hey, can you hear me now?
Oh, Keir's here, Matthew. I'm so sorry.
We'll get to it
We'll
later.
have to turn to Keir now for the time purposes. So I won't be able to hear the answer to that question unless you have a quick yes or no.
I think it depends. I think it's possible.
It always depends. Thank you, Matthew, and apologies to kick you back out. Hello, Keir. I will allow you to take the stage now and present your piece on US regulation.
Well, thank you so much for having me. I apologize for the delay. I swear that has never happened to me before, but let us dive into what is happening in the privacy space over in the United States. So as folks joining this conference will know, the United States is unique in that it is in a dwindling fraternity of nations that lacks a comprehensive national approach, setting baseline rules governing how personal information can be collected, used, and shared. However, it is a myth that the United States therefore has no privacy law. The United States actually has so much privacy law, arguably in some cases too much privacy law. Historically, the United States has taken a sectoral approach to privacy issues, passing particular laws focused on very high risk or high sensitivity uses of data, industries, or data practices. And there's some backstop authority from the Federal Trade Commission, which has authority to protect against unfair and deceptive acts and practices in the market. That can be a little bit of a vague standard for businesses working in the privacy data use space. What collection or use of data would a federal regulator consider as unfair? The Biden administration's FTC was actually quite aggressive when it came to enforcing against companies for privacy violations under unfairness authority. Under the new Trump administration and the Trump FTC, we're expecting a little less creative application of that standard in the privacy space. However, we all think that it's way past time for the United States to bring some clarity and pass comprehensive federal privacy legislation. There were two big efforts in this direction, bipartisan efforts to pass a national privacy law over the past few years here. Those were the American Data Privacy and Protection Act, the American Privacy Rights Act. They were bipartisan and they resolved two of the big sticking points that you often hear about in some ways. Should there be a private right of action? Should individuals have the ability to bring suit to enforce alleged violations of the law? As well as a compromise on the issue of preemption. To what extent should a national framework override what the states are doing? And the states are certainly being very, very busy. So compromises on those issues, but what we learn from this is actually the substance of a privacy law really matters as well, and important policy lines have to be drawn. And a big issue in these frameworks was that it wasn't entirely clear what data practices did these frameworks actually want to change at different points and in different versions of these bills. The question of how to address online targeted advertising was resolved through an opt-in approach, an opt-out approach, and sometimes banning many online advertising practices, often at the same time. So a lot of people will come on these and tell you, America got so close to finally passing a national privacy law. I'm not sure about that. I'd say we maybe got down to the 5-yard line and trying to enact comprehensive privacy legislation, meaning we only had 95 more yards to go. There was big opposition from both California, which has its own state privacy law, as well as the key Republican in the Senate Commerce Committee, Senator Ted Cruz. But what does the future hold? New Trump administration. We have new individuals in leadership. We have some gavels changing hands. Obviously, Republicans now control both branches of Congress and the presidency. Creates potentially a pathway to finally enact comprehensive privacy legislation. And the messaging has been that the debate around consumer privacy is now in for a complete reset. That APRA and APRA framework that I discussed really has its roots in debates on Capitol Hill dating way back to 2019. It's now 2025. We have many states that have passed privacy laws at this point, including places like Texas and Kentucky. And the presumption is that many of these lawmakers will be looking at what the states are doing when it comes time to start up these conversations about passing federal privacy legislation again. However, in the immediate term, it doesn't look like comprehensive national privacy legislation is going to be the priority for the key committees in Congress. Instead, the focus will likely be on children's privacy and online safety bills. Related, but a little bit different, narrower in scope, design and safety issues related to privacy, but touch on other concerns and issues as well. Just yesterday, the Senate Commerce Committee passed by voice vote the Kids Off Social Media Act, trying to ban individuals 13 and under from using social media sites and limiting the ability of social media platforms to engage in targeted advertising to teens. We would also expect the Kids Online Safety Act to come back this year, as well as an update to the federal Children's Online Privacy Protection Act statute. But really, where a lot of the action in terms of passing privacy laws is in the United States is taking place not at the federal level, where there's this vacuum, there's no comprehensive privacy framework, but instead in the states. And I'll try to run through quite quickly what's happening in the US states. And the story of our state-led approach to privacy legislation really kicks off in 2018 in California with the California Consumer Privacy Act. California is a very unique state in that it can pass major laws through a ballot initiative process. So a small group of people can write a bill. If they get enough signatures on that bill, they can put it on the ballot and it goes into state law. And California very much passed its law as a result of that process. And the story goes, a individual was at a party. He got to chatting with an engineer for one of the big tech companies. I wasn't there. Allegedly, this engineer goes, if you had any idea how much data we're collecting about you, it would absolutely terrify you. And he just so happened to make this statement to someone with the means to go out and write a bill and hire enough people to go out and collect signatures. And that's very much why we have a privacy law in California. And let that be a lesson to everyone. Be careful of who you're talking to and what jokes you make at cocktail parties, I would say. So that was 2018, and a lot of folks in our space were expecting there's going to be a California effect. Now, every other state will go and pass similar California-style laws. Did that happen? Maybe yes, maybe no. We've now got 19 or 20 or so states with what we would consider comprehensive consumer privacy laws, setting rules of the road for the collection, use, and sharing of personal data. However, the states seem to have converged on a different approach, not the California model, but the Washington state model. And it's actually a little funny that Washington state bill that was worked on in Olympia over multiple cycles never actually got over the finish line in Washington state. There are a number of differences between these two approaches. California is a little bit broader, applies to more data and more companies and more use cases, sets up its own standalone regulatory enforcement agency with rulemaking, whereas other states typically leave enforcement to the state attorney general. But the really big distinction between these two frameworks is that with respect to sensitive data, California is more of an opt-out style approach. Individuals can tell companies, do not use or disclose my personal data, my sensitive personal data for unnecessary purposes. Washington state framework, the model is much more, if you as a company want to collect or use sensitive personal data, you need affirmative, opt-in, freely given, specific, informed, and unambiguous. That's a standard most of you should recognize from the GDPR, consent from the individual. We're in a period there where 1 or 2 states would pass these privacy laws each year. Last 2 years, we've had 7 states each year pass these comprehensive consumer privacy laws. So the speed is very much accelerating. Not all of these state laws are yet in effect, but right now we're at a stage where even though we don't have that federal framework and standard, about a third of the US citizenry lives in states where there is a consumer privacy law in place. There are unique distinctions between each of these laws that makes compliance difficult in some ways for many businesses operating at a national scale. However, there is more convergence around this Washington Privacy Act model than many people feared in 2018 when states first started passing these laws. Okay, what do you want to watch for this year? There are a few major hotspots. First, California is in a rulemaking process to update the requirements under its privacy law. There's draft rules out there now. There's a comment period that closes this month in the 19th. And there are rules governing opt-out rights and access with respect to automated decision-making technology. Privacy law kind of getting into the AI space in a big way, as well as risk assessments and cybersecurity audits. This is a very controversial rulemaking process. Questions about whether the rules may be exceeding the agency's statutory grant of authority. And the agency's own prediction is that these rules will cost, in 1 year, just to California in-state businesses, $3.5 billion in compliance costs. And that is a very big number. Texas is also a hotspot state and is one of the most active regulators on privacy issues. Just introduced a big lawsuit involving the collection and sale of sensitive geolocation data, allegedly without proper consent mechanisms for insurance rate setting purposes. Definitely a jurisdiction to watch. Turning to Maryland, which passed a comprehensive privacy law last year, the state potentially represents a paradigm shift with respect to data minimization. Most state laws say that if you are a business, you need to identify the reasons that you are collecting and using data, and if it's sensitive data, get that opt-in consent. Maryland seeks to take a different approach by saying businesses can only collect and use certain categories of data if necessary or strictly necessary to provide a specifically requested product or service. Potentially a very different approach, and we'll be watching closely when that law takes effect in October to see how the regulators interpret and begin to enforce that very unique approach that tries to de-emphasize the role of consumer consent and put more baseline restrictions on what information organizations can collect and use, period. And then finally, I will just note New York State. The legislature has just passed a very restrictive privacy framework focused on the collection and use of health data, has a list of permissible purposes. You can only collect and use data for a narrow list of reasons unless you collect valid authorization. Valid authorization sounds a lot like consent, which a lot of businesses are familiar with, but there are unique elements of this valid authorization standard, including that you can't actually get that consent until at least 24 hours after you as a business first interact with a potential customer. So that bill is currently with the governor's office. There's a potential for additional amendments. It's one of these frameworks that many people at businesses are watching very, very closely. And I think that is it for me. I apologize again for the audio mishap, and happy to answer questions or turn it back to Robert if there's any time.
Thank you so much, Keir. 2 great presentations, 2 very, very complicated data protection and privacy landscapes. Keir, we're getting a lot of questions, and forgive me if you'd rather avoid this one, but a lot of questions about the EU-US data privacy framework. Now, of course, that's a question for the EU on the one hand and the US on the other. Do you have a straight answer for us? Will it survive from your perspective?
That is a fantastic question. It's one of those issues that seems to bubble up every 5 years or so, and it seems like we are right on time for this issue to happen again. I would actually point to the Project 2025 document, which many conservatives associated with the Trump presidential campaign, and now many of whom are associated with administration, did lay out something of a very kind of America First approach to the issue of cross-border data flows, some suggestions that if Europe wants to continue to benefit from the United States intelligence services, there should be a reliable, consistent approach for the exchange of data between our two continents. Obviously, our two continents and the economies are very intertwined, so there's going to be incredible pressure on both sides of the Atlantic, I think, to make sure a durable framework can be in place so that data transfers can continue. So I don't think that was a straight answer, but it's at least where I encourage folks below.
It was clearer than many people would provide, I think. So thank you very much. I will say it's getting easier to persuade clients to conduct transfer impact assessments on this side of the pond, given everything that's happening in the US. Well, thank you so much.